So I think without any further ado, I will introduce our plenary speaker, who is Ruth, and we're very lucky to have her because of her involvement in developing guidelines for what do you call it? Legal information literary standards. Okay, what I've called, the sorts of skills, information retrieval skills. Working your way around information in law. And you're going to talk to us and take us on as you want.
Oh, don't say that.
We're running a bit late, so don't worry about it. Thank you.
What Rosemary said about working with your institution just made me think of when I came to Oxford, which is 10 years ago now. I had thoughts of doing the same sort of integration of library skills into teaching as we've done at the University of Melbourne. Because it was a type of teaching where there were subjects every year and there were large lectures and quite large tutorials of 50 or 60, or no, 20 or 30. And I thought we'd fit into the lecture program and be able to, because what we've done is we would take the skills part of a property law topic with the librarians taking one little part of it and working with the academics. And we'd do the same thing at Oxford. I thought, it's easy. Oxford takes tutorials, it doesn't do lectures, so we had to review totally what we were doing there. So it is, you're right, just change it varies so much from place to place. So what I want to talk about briefly, not so briefly, as briefly as I can, what we should, as law librarians, why we should be involved in the whole aspect of legal information literacy, as we call it. Look at the evolution of the standards over the last 5 years or so, and briefly look at LETR. So, why does information literacy matter to librarians? It's for the same reasons I originally came into librarianship, from teaching. Our colleagues in academia teach subject content, but our strength is in a few things: consistently organising resources in a way that our users can become lifelong direct learners who know how to find information in any given subject. And we have in the past taught strategies and shortcuts to finding the right resources, which are the basis of all the subjects. We know that the information needs to be findable so that it can be read, reinterpreted and understood. And that's why in a digital world it becomes so much more important that we're leading the charge and not floundering in the way. We see the so-called digital natives and know that they actually do not know much when it comes to comprehending what lies behind a search engine. So imagine a librarian at the time of Gutenberg explaining the new democratic object that was the mass-produced printed book and creating an affordable and accessible source of what had been a very restricted resource at the time. We've had 500 years to master that technological innovation and to embed it in our teaching, our research and learning in myriad ways. Books evolved into articles, magazines, loose parts, bound volumes, volume accumulations. And we're all very comfortable with those sources, and also with the book-based reference tools that we used to use: encyclopedias, gazetteers, dictionaries, atlases and indexes. And now all these traditional tools and objects have been turned on their head. Bits and bytes, they're in bits and bytes, and they have no visible or tangible structure. And we expect people without our exposure to this background understanding to be able to do research just because they've grown up using a keyboard and a freewheeling search engine. In some ways, it's analogous to saying that because you can read, you can produce excellent prose. So if you look behind me, that's just 15 years worth of developments in the digital world. And many of our students were 2 or 3 when some of those things came along, some even younger. It's time to stop assuming that familiarity with the hardware equates with understanding its context and its outputs. There are huge knowledge gaps in the applied legal research of law students and trainees, which can only be addressed in formal teaching and training. The General Counsel of Kia Motors in America, Casey Flaherty, said, "It's a myth that young people are digital natives. They know how to consume the content, but not how to create it or where it comes from." These concerns have been around for quite a while, and it's not just students. This article was written in 2008 by Nicholas Carr. It's not just the students, but the supervisors who've been identified as needing training in research that was undertaken by bodies such as the Research Information Network in 2011, which looked at the roles of research supervisors in information literacy, and that report is on the RIN website. Recently, a colleague of ours at Cambridge, Daniel Bates, provided an excellent overview of the literature to do with legal information literacy. And he draws conclusions which are based on 13 years of experience with undergraduates. And he states that although students studying law today have more experience of online services and searching, and a greater use of technology in their everyday lives, they are in many ways less equipped and less capable of handling complex legal research tasks. While the digital natives can certainly conquer their new landscape, they will need help equipping them to do so. And so this was an analysis that he did, which appeared in LIM. I think it was published in LIM last year. In the early stages of the digital revolution, academics and teachers often deferred to the technological prowess demonstrated by pupils and assumed it meant a deeper understanding of the content than really was the case. It was a bit different, however, I think, for librarians. As the internet evolved, we were involved because versions of our resources had been started to appear on the web. For law in particular, we had Lexis and Westlaw databases, and they were pioneers in e-access even before the internet. Many law librarians in common law jurisdictions, countries especially, were teaching legal research in the late 80s and 90s as a normal part of our interaction with our users. We were dealing with complex materials, not only law reports and legislation, but digests, encyclopedias of law, citators, words and phrases, as well as monographs and journals. So we had the complexity of the structure of the material as well as the information side of it. Each type of resource played a part in comprehensive legal research, and knowing what they were and how they interacted with each other would make it easier to know how to navigate them, made it much easier for law students and for trainee lawyers when they were working at firms. And I think law librarians were always far more involved in teaching than our colleagues in other libraries, who usually were more involved in inductions and limited areas. And yet, as a group, overall, law librarians have been somewhat slow to come to accepting the role that the information literacy needs to play in our teaching. For a while in the 90s, we were concentrated on a myriad of databases, resources that we had to teach our users to show them how to use them, had to show the role of Boolean operators and their various individual idiosyncrasies. There's a need now for a broader approach that addresses skills in legal information literacy, and that's not just amongst the students, but also amongst those who supervise and teach the researchers. And we as law librarians, I believe, are uniquely placed to provide a lead in these developments. So what I want to look at now is the evolution of the standards over the past 5 years. And although the standards are not, as Rosemary said, the way to do it, I'll explain why I think they're important and where they've come from is important. There was a general movement to identify literacy skills in the 90s, and National Library Associations drew up core skills and came up with tables and information. But they were fairly broad brush. They were fairly more to do with like reference skills than other things. 5 years ago, a group of our American colleagues, law library colleagues, got together and started to tease out the competencies that they thought were specific to the requirements of law students. They referred to the American College of Research and Libraries, College and Research Library standards as a starting point, and then they took them and they took the iterative process of applying them to the elements of legal research. And after quite a bit of consultation, the AALL Principles and Standards of Legal Research Competency were officially approved in July 2013 by their board. And they're based on these 5 principles. Successful researcher possesses foundational knowledge of the legal system and legal information sources, gathers information through effective and efficient legal research strategies, critically evaluates that information, applies that information effectively to resolve a specific issue or need, and distinguishes between ethical and unethical uses of information and understands the legal issues associated with the discovery, use and application of information. So then within each of those 5 overarching principles, there are several standards under which are listed the competencies required to demonstrate the standard has been achieved. So that's just an example of the very first one there. In 2011, this issue was raised at a BAL conference by one of our colleagues as to what BAL was doing in terms of information literacy, and the BAL decided to establish a working party which was established in 2012, and I was fortunate enough to lead a very enthusiastic group representing all aspects of law librarianship, from firms, from the inns, from academia and courts. And with that working party, we decided to take a slightly different tack to our American colleagues. And what we did was we reviewed the legal research standards outlined by the English legal regulatory authorities. The solicitors, the SRA, the Bar Standards Board, and ILEX, is Professional Standards Board. So the resulting paper was the Bar Legal Information Literacy Statement, which was published in 2012. July, we asked for comments from our colleagues, and what we have now is the final version. And we came up with these 5 research skills. Firstly, to demonstrate an understanding of the need for the thorough investigation of all relevant factual and legal issues involved in the research task, the ability to undertake systematic and comprehensive legal research, the ability to analyse research findings effectively, the ability to present the results of research in an appropriate and effective manner, and then with continuing professional development, acknowledging that this does not finish when you finish studying, refreshing the legal research skills acquired by a modern lawyer. Within each of the research skills, we set out learning outcomes, accompanied by appropriate knowledge, understanding and skills to provide examples and assessment criteria. So the aim was to provide a working document which our colleagues could use in evaluating their own legal research teaching programs, and to act as a guide to suitable evidence which can demonstrate a given learning outcome. Now these are all on the BAR website. You can download them, the standards from the BAR website. We were quite fortunate with our timing because we were then able to actually meet with Paul Maher on the LETR as the LETR Education Committee was getting established, interviewing people. We were part of the interview today. There is one other body that has taken the skills and is also applying them for law, and that's the Education Committee of the International Association of Law Libraries. They're looking at trying to come up with skills that are applicable in public international law. They had the first workshop last September in Barcelona, and they're following up during the course of the year with comments and hope to, in their September meeting, to come up with some standards that are useful for public international law as well. So in other words, it's sort of spreading a little bit wider than we originally hoped. The review, the Legal Education Training Review, being the first comprehensive review of legal education in England and Wales since 1971 apparently, this project was quite important for us, that we got a bit of a say in it. And we were very pleased because the stakeholders were mainly students, practicing legal professionals, and then there were the allied professionals such as us. One of the key objectives of the LETR was to look at solicitor skills and whether the courses were actually preparing students for with relevant competencies. And there was a survey of barristers, solicitors and legal executives, where legal research ranked 13th out of 25 important skills. So it wasn't at the top, but it was certainly not at the bottom. The LETR, in the LETR findings, it was widely recognised that the skills, these research skills, were not sufficiently acquired by the end of the academic stage of training. And it was also found that moving from academic to vocational courses highlighted these gaps in legal research competency. The work of the Information Literacy Group contributed to the training review on how the legal research skills are taught at the academic stage, and we did focus on the legal research habits of the trainees. And the report actually acknowledges the input of library research professionals and their contribution to it by providing evidence of what's happening in the real world environment of the workplace after students have left legal education. And the report included the following issues in its evidence. The trainees appear to be generally unfamiliar with paper-based resources by comparison with digital resources. The trainees seem to depend on one-hit-only searching. In other words, they don't check things thoroughly and contextually around their findings. And the trainees use Google extensively, and their searches tend to be shallow and brief. And the report also comments on the growing trend of distance learning courses in law, and that you have to take into account that those students haven't got the physical provisions that other students have got. And it does, the report does say that the literacy statement, and also this thing which you can't read but which is also on the VAL website, which is the Skernal Digital Literacy Lens, are key documents for the development of digital legal literacies, as they provide a framework for the statement of outcomes, as well as for forms of learning and assessment. So again, in the version that's on the web, we actually highlighted the aspects of the digital lens, literacy lens, that we thought were quite applicable to law, separate from the general legal research. So that's definitely something that's worth having a look at. So there was consensus that these skills need to be addressed at a number of stages in legal services, education, training, there were also concerns that research skills were not always well taught. So recommendation 11 of the report states that there should be a distinct assessment of legal research, writing and critical thinking skills at level 5 or above in the qualifying law degree and in the graduate diploma of law. So we actually have something quite concrete to aim for. And whilst the recommendations are aimed at legal education regulators and providers, it's a valuable piece of research which can inform the teaching practice of law librarians and in university law schools and also in commercial law firms. It provides us with a great opportunity to demonstrate the expertise through this, of legal law librarians through this sort of training. So the momentum is growing to deal with the problems that are starting to become evident in current approaches to legal skills acquisition and legal education. And with the standards as a starting point, we're able to provide an agreed and accessible, we think, set of standards that can be met across a wide variety of legal education environments, from small tutorial or face-to-face to larger group teaching and distance learning. And on the screen here, what we did with our course that we teach at first year course, which is still separate, unfortunately, from the general topics, but it's a compulsory first year legal research and mooting skills program. And we decided to apply the literacy statement of the standards to the units that we do in our courses. So what we did was we looked at what the learning outcomes were and the knowledge that was meant to be there, and then we looked at what the students are actually, we asked the students to do to demonstrate that they have acquired that skill. And by going through what we do methodically and looking at what the standards were, we found that we were able to rejig some of the things that we were doing, to change sometime. In fact, we've changed quite a bit. The way we teach. I mean, we're very, very lucky. We can do small group tutorials, but also the order in which we teach things, the emphasis we place on certain things. By ending up with a moot at the end of this as the assessment for this whole course, by ending up with a moot, it was really pleasing for me as an old hand that most of the students wanted to go back and use books to do their research for their problems, rather than do a lot of it online. So that was so they wanted a refresher session on some of the tools that they needed to use. So that's just an aside. But by doing this, we did find that we did need to go back to some of the things later in the year that we thought we'd covered at the start of the year. So it was quite good having the standards to help us clarify what we were doing. So I think basically what I want to end up by saying is that it's important to step back and to look carefully at what is being done in all of our legal education structures and to examine whether the need for skills-based competencies would help you make your legal research teaching more useful and realistic for the students. And whether you review what is being taught on academic criteria or on standards set by the profession or a fusion of both, I think the experience of doing this sort of thing is well worth the effort. And this is what we're talking about for the rest of the day. So, thank you.
We've got time for questions and discussion, so do you mind, Ruth, answering questions if people... So it's open to you. Anything that someone would like to ask? Ray? Yeah?
Just a brief clarification. You mentioned training, you talking about anything moved, you talking about the book-based session being a refresher on. When does this course, basically a year-long course in the first year? Or?
It's a year-long course in the first year, but it's only about 4 hours a term that we are actually involved, as in the teaching side of it. It's 4 hours a term in first and second term, and then the refresher is at the start of third term, which is when they do their merge.
But then each student will be in a small group having those 4 hours, is that right?
Yes.
So you're repeating?
Yeah, we were doing it in larger groups, and this year, this academic year, because we're fortunate enough to have enough library staff to do it, enough librarians, we actually took tutorials of 4 students, but it meant that we were over a period of 3 weeks, each one of us were teaching 20-odd tutes, 25 tutes, so it was quite intense. But we felt it was this was our experimental year, and we've reviewed it, and we are going to continue along those lines. But the MOOC thing is quite interesting because the students all have to do it. They can't get out of it, and they have to work in pairs for it. So that's reinforces it quite nicely.
Sorry, did they explain why they liked using a physical book? What actually drove them back to that way of...
I think it was the nature of the problems that they're given for the MOOC made them suddenly realise that they have to bring things together, that they can't just look at a case in isolation, that they might need to actually look up a digest to get a feel for the topic or what the leading cases are in the topic, that they might need to refer to words and phrases for some reason, and they might find it easy to have that next to them while we've got a citator open. There were various things. They just wanted to know what role did these things really have, and what was the purpose, when they came to actually having to get up and argue a claim.
So who sets the MOOC problems? Are they linked to one of the academics?
We have academic input into them, but we run 5 or 6 different problems across the 200-odd students, and they just...
So are they therefore researching something in isolation, or is it part of something that a subject they'll already have been studying, like contract law or land law?
At that stage, it's really in isolation.
Right.
It does take some of the things that they've had in their first couple of subjects. Constitutional a little bit. We tend to have it on because that's what they've done at that stage.
So it really is researching from scratch because they haven't.
Yes, yes. Whereas the initial tutes we do, the tutorials are start from the point of the reading list.
Yeah.
Frankly.
Can I ask something? I was struck by the fact that you showed the guidelines from the AALL, the American ones. There were two things that didn't seem to me to make an appearance on the bio ones. The critical, using sources critically, which is the third one I think, and the last one, which was the ethical. And it just makes me.
They are in there.
Yeah.
But we didn't put them as skills. We put them as learning outcomes. Was that the phrase, Natasha? That we incorporated them into the next level down, rather than putting them top level like that.
That's useful to know. But I suppose what struck me about the module you've been talking about at Oxford and the assessment is that those sorts of skills which can be assessed by a mood are very particular sorts of finding the law skills and what is the authority skills. They're not critical, socio-legal, contextual, all those other things. And that's where, when I said that law skills are different, those are the sorts of skills that you were training would-be lawyers in. And most of our students are actually not going to be lawyers. And many universities hold steadfastly to the notion that law is a liberal education. And what we're actually teaching, of course we want them to know the law. But when we're teaching research skills, it's actually just saying, well, what's wrong with the law? Not what is the law, but what's wrong with it as well. Is there room for that in there?
Yes.
I think really because our guidelines were aimed, the target audience wasn't the student.
No.
It's the law librarians about teaching. So we can only we can't do the interpretation. So those couldn't really be articulated in the guidelines.
Which actually suggests exactly what I said before, which we're talking about two different things, and I did not realise that. That's really interesting. So the kinds of legal research skills that librarians are concerned with are the ones about finding the information and treating it properly. But, yeah?
In my case, no.
Okay.
I'm a policy sort. Partly, I don't know, because I'm doing that, there are a lot of colleagues of mine. Lawrence Smith, for example, is doing a PhD in critical information literacy. And it's a very big move. So when I stand in front of my students, one of the key messages I give them is, yes, you have to find what the law is, because that's what the market is. But in some cases, family and policy models, you are being asked to think, is the law right? Why is it the way it is? And I also teach sociologists and criminologists, so it's natural to say, you must question everything you read in here, and I always tell them to include meaning. It's a question of answer. So I think for a lot of us, we do say, don't just take what's in front of you. You have to look at it and think, well, where's that come from? Why are they saying how this is really interesting? So there are two different aspects. If you're in a contract class, we might very well say, well, this is what you're going to find out. This is the case, and this is what it is. Critiquing it is of no use to you. Whereas if we're in a different kind of module, like say, but with a family law module, we do put across, this tutor wants you to think about why is family law the way it is. So it's not as divergent as it might seem. But again, it depends on context and what you can do.
Again, on context, we were very aware that our guidelines had to support librarians in academia as well as those in practice. And what some practice-based librarians and law firms have done is use the guidelines to create CPD points. So that level of depth isn't needed in that context.
I know that that's what slightly worries me as an academic, and I was going to ask if that was it too, that the fact that you're actually thinking about what the firms are asking for, and some of the firms, I think this isn't true of all of them, because otherwise they wouldn't take all the Oxbridge graduates, but firms want people to have legal skills and they don't perhaps value the critical skills as much. And is it the influence of that lobby, those providers, those servants, if you like?
To some extent, what we were doing was looking at the training side of what's expected of us as librarians, or we think is expected to some extent. And we use that, but the idea, if you read further into beyond the top 5, we tried to make all of the next level down applicable in different situations, so that somebody in a first year law degree with first year law students would interpret it in their work situation differently to somebody who's working with the diploma of law students, so that it can reflect all our different workplaces, and therefore we can adapt. And that's what I meant about there were things in there that we obviously couldn't adapt easily into what we're doing at Oxford. But the things about scope and ethics and lack of plagiarism and all those things, you work around into those skills.
I think also though, isn't there a slightly sort of, it's a slightly false division saying, you know, we'd be critical analysis, different types of research around law, because you've got to get the law before you can, and one of the things that I find my students do when they do research, I say, is they'll take a bit about the law from some critical article and not realise that it's the law and not the criticism, or they'll do so it's all in a sort of swirling mess in their heads, and part of what they're not able to do is work out, well, this is the law because it's in the statute, and this is the grey area because the case law is conflicting on it, and this is the criticism, the academic critique of what that grey area is and why it's grey and why the judges are not, you know, kind of arguing with themselves or saying the same thing in different words. So and one of the things I like about that bio sort of level is I think it takes you through that, and I think unless you can do the mooting level of analysing the actual law, it's very difficult because there are grey areas to law and there are fixed bits to law. So my subject is family law, and there's something like there are various rules around who is or isn't a legal parent, for example, and it can't be submitted that argued that possibly the woman who gave birth is probably the mother. She is the mother, because that's the rule.
Yeah.
And you know, so you get this sort of confusion going on in the students' heads about where all these different bits of information fit in. So I think that sort of levelling of like, well, we have to find stuff, we have to understand what it is we found, you know, and is it authoritative, and then, you know, how does it all fit together? And I think that's one of the things about research skills is that you can't do that in one library session.
No, that's very clear. And in fact, many of us would say you start with the law in the first year, and in the second year you introduce more else, and the third year you hope that they can do those high level skills. Yes, that's very clear. Yeah.
At Durham we also do a mood, and I think that's fairly new at the end of our skill session. It's interesting to note that you don't do it on a particular subject that they teach, which is what we do. I just wondered whether or not you have skeleton arguments, because I think that picks up then on the kind of the ethical and the reference issues, and maybe almost trying to highlight to them when they're quoted, then it can go to them, but it's not, that's not the law, it's you've got to go to the cases. Do they have skeleton arguments?
Yeah.
You don't do
Well, I don't think we did it with all of them. I think at the moment there's an attempt to try and work out the best way of doing it. So I think the first year we did it with 2 groups. So we're sort of looking at different ways of improving the mood as well. So it's not everybody.
Okay, shall we end that? That's terrific. Thank you so much.